Welcome back to Haz'el Inspirations, Legal Issues, Part 4.
We had talked about this. We had said that it's a circuit court or the county hands down that, okay, well, you've done 3 years. We're going to just give you probation, time served for those 3 years. And then 2 days later, you get transferred to another facility. So then the whole law changes because you're not any longer underneath that jurisdiction, correct? So then you go to a state or federal facility. So now whatever that other facility said that they were going to give you for time served, now you have to fight with this other jurisdiction and say, okay, well, they just told me I got probation, I can get out. Well, sorry, but you got transferred. So now, you got to start the process all over again. And, you may have to do 5 to 10 now.
Well, you don't start the process over again because there's no process that you can do for that. But what you got to do is you got to reopen the original process. So you got to basically open the first one back up. So it's its own case, it's assigned its own case number, right? So you have to be careful or conscious of the fact that every action basically is what they call an independent action. So you could look up like independent actions in 8.01 428 so of the Virginia Code. So basically everything is an independent action. Say you get a case number, your criminal case code number, say it'll be the year and case number code and say FE or whatever it'll say.
Right.
And then that is your criminal case code. Then you get an appellate case number. That's an independent action, basically. It's based on your criminal case number, but it has a separate number.
Right.
So then you get, if you go through the Court of Appeals and you go to the Virginia Supreme Court, that's a separate case number. They're going to give you a different case number.
Right.
So each one of those are independent actions. So if you have an action, like say you made a request for reconsideration of time within the 21 days on your conviction, that is attached to the original case number, okay? So what you're working on when you file those after judgment motions, that's not the appellate motion, that's an after judgment within the 21 days.
Okay.
And that's the one that you're talking about, say you were trying to get a reconsideration.
Yes.
If you got moved, right? If you got moved, that case number right there is the case. So that case is, so now what you're going to do after that, if say you got moved and you had not finished with whatever you were supposed to do from the reconsideration motion that was pending, you must access that case number right there. So whatever you are putting in, you must say, this is RE or regarding case number, the criminal case number.
Okay.
So some people, what they're doing is they are starting a new case number in the DOC, and then they are shooting that down and saying they don't have jurisdiction.
Right.
You don't have the right to establish that new case number about that issue from in there. So what you do is you try to go according to the old case number and you say regarding this. And this is why I want this case, this part reopened. Now they can still try to hit you with lack of jurisdiction, but you got to know that, are you starting an independent action or are you opening the same file from the first? Are you starting a new folder or are you opening the old folder?
Okay.
So you got to keep track of your case numbers as you're moving through. You want to know if you're opening a new case or if you're trying to do something in regard to an existing case.
Okay.
So with habeas corpus, it is a new case. It is a new case. So you must put everything into that case. So it is a new box. See, they close that box. They close your trial box. They push that box over here. They put the appeal and everything in there. Everything that was regarding that, they put in that box over there. When you file a habeas corpus, that is an independent action.
Okay.
So it's really, they say it is a civil case. It is a civil case in regard to a criminal matter, but it's handled in a civil way. meaning it's by civil procedures. And civil procedures, you must permit or you must submit everything into that case yourself. It doesn't exist unless you put it in there.
Okay.
So
Yeah,
some people,
that explains
make
what we
that
were
error. And
discussing. Yes. Yes, thank you.
right. They might think that they're referencing things that are not in the new box that they made. They made a new box. Now you could take the stuff that you have from that was relating to the other case and you put it in the new box, but you must put it in there. So now if you don't have it, now you can request that the attorney general or whatever get the transcripts or whatever so you could put it in this new box. But they are deciding this on an independent case number. And then they're seeing, based on this civil attack that you are making, can we do something about overturning the conviction? So those are very technical matters, right? That if you're not all the way up here, you could be making errors and they be slap boxing you around the whole time and you won't understand what they're saying and why you're losing.
Right.
Because they're being particular.
Right.
They're using this number and you're saying this number and they're saying we can't do anything about that case and you're going,
right.
But all habeas corpuses deal with that. But you're relying on things that's in that box and that box is taped up. You should have made a new box. And that's what this is. You got a new case number, new box. You got to put everything in here and you must prove that on this issue right here. But it relates to that. Yeah, but you got to put it in this box.
And instead of explaining it when they write you back or respond to your motion, they do not. They just deny it. They don't give you a detailed explanation. Or they may say this is not pertaining to this case number.
Because what their logic with that, their logic with that is that they are not to teach you law or advocate for you. They're just to make decisions. So your ignorance of the law is no excuse. So they can deny your case and give you a reason for why they denied it, but they're not going to teach you how to do it.
Correct.
So they say that's on you. Whether you want to represent your case yourself, and you can say all day long, man, I didn't know this, I didn't read that, I only have a 3rd grade education. They don't care. They say ignorance of the law is no excuse. That's their mentality. That's their game. If you playing football and you run the wrong way when you catch the ball, the people don't care. That's a touchdown on the other side, or a touchback, or whatever you want to call it. But they're not going to give you points and be like, oh, man, you know what? He's foreign. He didn't know that he's supposed to run this way when he caught the ball. They're going to put the points on the big board on the other side and keep on moving.
Right.
So that's how they look at that. But the only difference is they're playing with lives. So your ignorance of that is, in their eyes, no excuse. So you have to know, you have to go in at least knowing that it's a complex situation. At least knowing that, hey, man, I'm not going to just resolve this by writing some stuff on a piece of paper and not know where it goes, which court it goes to. Because you can jack your case all up by sending your papers to the wrong court.
Right.
And the wrong court assigns you a case number.
Yeah.
I mean, there's so many problems because people don't know where you're at. You don't know. You're in a jail. You don't know what court you're supposed to send it to. Some people might write straight to the United States Supreme Court. You don't know. So you might write straight to the Virginia Supreme Court and they'll say, okay, I'll take this handwritten letter as a habeas corpus. And then they'll send you some paperwork back and it makes it look like you're going through a legal process, but really they put a nail in your coffin because they're just trying to close the case off. And they say, well, you already filed one habeas corpus, you only get one. You get one unless you have new evidence for another, second and subsequent. So the one that you filed, you better know what you're doing when you file it.
You only get to file it once?
Yeah, you get one. You get one shot unless you have some other issue that could not have been known at the time that you filed the first one, or a new law that came into effect that was not in effect, then you have one.
So what happens when you're trying to prove your innocence and, like you just mentioned, you filed the wrong paperwork, not knowing, because you have that lack of knowledge. And I guess
there's different processes. Like, so if you're saying you are actually innocent, then there's actual innocence petition. So,
Okay.
but I'm talking about habeas corpus.
Okay.
So when you're saying actual innocence, then that's what they call an actual innocence petition. And that's when you have one on biological, one on non-biological. And then you have, like I said, the void judgment petitions that people don't really know about, but all of these cases are dealing with void judgment. So
Okay.
void judgment petitions are challenging the court's jurisdiction. They're saying that the court did not have authority to do whatever it is that they did, or they weren't supposed to be hearing your case in the first place. So the court always has jurisdiction to determine whether it has jurisdiction. So if there was like, let's just say a regular jurisdictional issue, if you say this did not happen in the state of Virginia, it happened in DC. Like there's many cases like that. People get in a shooting and they go straight over the line. They go over Constitution or whatever. They go into Fairfax and they get busted in Fairfax, and then they charge Fairfax for shooting and be like, well, the shooting actually took place in DC. Or they charge them with eluding, but there was no eluding that took place in Virginia. The eluding took place in DC. So you end up having a whole trial and get convicted for eluding in the Fairfax court. And then you say that, well, that court had no jurisdiction. So that a jurisdictional issue can be raised at any time in any court in any manner. So, but there's other ways that a jurisdictional issue will come up. Jurisdiction also comes up for violation of due process. Violation of due process presents a jurisdictional claim, because once they violate your due process, the court cannot proceed. They can't go on to another stage if you did not get your rights at this, or your rights were violated at stage B. You can't go to stage G. So everything after B is void. So that includes anything. That includes what you're mostly concerned with is the judgment of conviction and the sentence. So if there was a violation of due process back here, then the subsequent judgment is void. And that can be raised in any court at any time in any manner. So there's people that's in prison right now, and they're so focused on the habeas corpus process because that's what everyone is trained to teach you. All right, this is what you got. You got your appeal and you got your habeas corpus. But no one's saying anything about, well, you can also attack it after that or before that on the void judgment petition. And lawyers know that, but they're part of the system. So they reserve that, really, in my opinion, for themselves and whoever else they want to get out. But you can attack your conviction years after the statutory timeline is run out on a petition for relief from void judgment. So, that's something that I always like to let people know, because some people have despair, or they start, they trick the time up. You know what I'm saying? Once you feel like, man, there's no way I can get out of here. I already filed the appeal, already filed a habeas corpus, but did you file your void judgment petitions? Did you file your actual innocence petitions? There's other things you can file. You know what I'm saying? You can file even that. I can file stuff right now, which I'm going to. You can file stuff even after you get out against your conviction. So you have to have, you can't, and you got to let people know that, so that they don't go in the system and trick up, which is make their time harder, getting into fights, getting crazy charges, getting into stuff that you definitely shouldn't be involved with because you think that there's no way out, picking up new cases. So you jeopardize yourself when you think that you have no hope. But once you know that there's other processes in place, then it's like, yeah, look, keep your nose clean, man, because we can still do this. And, you gotta, hope is not lost. And sometimes you need that. And there's many other ways to get our people out of there, but, hopefully these will come with further conversations. And, because there's a lot that we must discuss so our people can understand what the system is, what you are in relation to the system. Right. So, it's a lot to know, but once it's like the Matrix. You know what I'm saying? Once you understand it, then you understand how it moves, how it functions. You know how to come in and out of it.
Right.
But if the people know that we're not taking that time to have these conversations, that's one thing, you know, they feel a large threat about Moors and stuff like that, because Moors have that type of knowledge. That's what we have to discuss. We have to know that stuff. Law governs all events. So, and it's not to learn it so we can circumvent responsibility. It's so that we can understand our rights in relation to whatever entity it is that we are up against. So, you know, you have to know those things.
Mm-hmm.
That's right. Are you going to touch a little bit more on the void judgment petitions, or
Could not hear what you said.
I'm sorry, are we going to touch a little bit more on the void judgment petitions? Before
Yeah,
we go
like,
to break?
you know, yeah, I can touch more on void judgment. See, it's not as complicated as people think. It's actually it's the most straightforward legal petition that exists for relief. All of the other stuff is, all right, say in the state, all of the other stuff is a way to prosecute a void judgment. So even the appellate process, the habeas corpus process, they are all arguing that the judgment is void, because you're saying that the person's due process right was violated. Now, the only reason really why you should use the appellate process or the habeas corpus process, not all the way the habeas corpus, but especially the appellate process, is if it is an issue that only relates to state law or state codes or something like that. But the void judgment process is always available, and it is, in fact, what you are doing when you are saying that he wants a right to appeal, or his case should be overturned on appeal because of this violation. You're saying that the judgment is void because his due process was violated. Same thing when ineffective assistant counsel claims. The right to effective assistance of counsel is a due process right. It means you have to have that. So if you're saying that my lawyer was not effective because he didn't do this, you're saying that the judgment is void. So if you read, there's a case called I think it's Zerps versus Johnson, or Johnson versus Zerps. But they explain, now they started trying to change the law or change the language later on as time went on in the United States, and some of the ways that they explain stuff in court cases. But what they explain in there is they're saying, like, if you were denied effective assistance of counsel, then the judgment is void because you cannot proceed without a lawyer that is effective. So the judgment, whatever subsequent order or judgment that the court made, is void. So you are always arguing a void judgment petition. The only difference is, let's just say, for streamlining processes or streamlining reasons, say for the order of the court, they created these codes that deal with filing after judgment motion, filing a appeal, filing a habeas corpus. And they will say, well, in order to make this more orderly so the court clerk can know where to put this paper and which court it should go to and how to rapidly get it through, we set this for your convenience. So you basically make this void judgment argument in this type of a process. But in that process, it has limitations and statute of limitations and things like that. Now, when you start doing that, you're kind of hindering yourself a little bit, because you're going according to a narrower set of procedures and timeline. Now, and you might rush it, whatever. But when you're making a void judgment petition, it could be raised in any court, anytime, any manner, and it might be the exact same things that you were raising on the appeal. So, not to say that I'm encouraging people to bypass their appeal process or the habeas corpus process, but that is what all of the processes are. You're saying that the judgment is void. The only difference is that you're raising a void judgment on a petition for appeal, or you're raising a void judgment on a habeas corpus, because you're saying that the court doesn't have jurisdiction because they violated my due process at this critical stage of the proceeding. So therefore, the case has to go back to there, or it has to be thrown out. In
Okay,
many
I
cases,
think
in certain cases, it has to
DK
be
had
thrown
a
out.
question for you, Ford.
I wanted to ask you questions about the suppressions.
Okay.
Basically, how does that work? When you're trying to get something suppressed, because I have an associate that wants to get something suppressed, and he was asking me, how does he get something suppressed when basically he's going through he's going through a situation where he currently got out of he was incarcerated, and he got out of county jail, and all right, let me tell you his situation so you can pretty much better understand. So he was incarcerated, and he took a plea deal, right? And they forced him into taking a plea deal, and he backed out of it, and basically he's going to court, and basically he's basically he's taking all his charges back. He's basically trying to not take anything. He doesn't want anything on his record. You know what I mean? Because he knows that he's innocent. So he's trying to get he's trying to get something suppressed. So, and if you were in that situation, how would you go about it? What would you do?
Well, what he's saying is that the judgment is void. So think about what I'm saying. He's saying that the judgment of conviction is void because someone forced him to take a guilty plea.
Right. Because he had no money. He couldn't afford lawyer fees. He couldn't do anything at that point.
So when you're saying that, what you're saying is guilty pleas cannot result from what they say involuntary, coerced, or unintelligent.
Right.
So it cannot be unintelligently made, which means I don't understand, I don't comprehend. So something's being misrepresented, or I don't understand the law, or I don't understand why I'm pleading guilty.
Right.
Voluntary means that it can't be forced. No one can put a gun to your head. You have to choose to do it. Like you volunteer. Unintelligent, coerced, or unintelligent, or voluntary. So it can't result from or unknowing. So you have to have knowledge of what you're doing. You have to have knowledge of the terms and conditions. So if he's saying that, then what you're saying is that the judgment is void.
Right.
So that can be attacked anytime. Now, if he's saying that, now the reason why I pled guilty was because
he pled
evidence
guilty
was supposed to be suppressed. Like it sounds like it's a compound issue. He's saying this is what happened. There were some issues. There was some evidence that was supposed to be suppressed because the police violated my Fourth Amendment right. They just reached in the car and took out some evidence and beat me in the head and snatched me out the car and threw me in a thing. And they made me make some statements, and they didn't tell me I had a right to remain silent, and they were going to use all of that to convict me. So my lawyer was supposed to move to suppress those things. He was supposed to try to suppress my statements because they were taken in violation of the Fifth Amendment and my right to remain silent. They were going to submit some contraband or whatever it is from the car that they illegally obtained because they didn't have a warrant, and they just went in my car, and I didn't give them any authority to do so, nor did the court, and nor did they have probable cause that was sufficient to show that's why they took this evidence out from under my seat. So they violated my Fourth and my Fifth Amendment right. My Fourth Amendment right to illegal, to be safe from illegal searches and seizures, and my Fifth Amendment right to be free from making statements if I want to remain silent and making incriminating statements against myself involuntarily. So my lawyer should have suppressed those two issues. My lawyer failed to suppress those two issues, which is why, because those two issues were going to come into the trial, what's the point of going to trial if you're going to bring up these two things? You know what I'm saying? This issue should have been suppressed. Both these issues should have been suppressed. But since you didn't even file the suppression, or since you screwed up the suppression hearing, you didn't even argue it right. You know what I'm saying? You filed something, but you went in there and
That's what I told him.
You basically went along with them. Like, you made my case go to the next stage. You failed to do what you were supposed to do in the suppression hearing. It made my case go to the next stage. So now I'm filing against you.
With that?
Say that again?
Is there a reversal process with that for legal representation not being effective?
Yeah, so what you're saying, like, say in one situation in the Fourth Amendment issue, you're saying that your lawyer was ineffective in the suppression hearing. So there's a case called, the United States Supreme Court case called Kimmelman versus Morrison. So Kimmelman versus Morrison deals with your lawyer's adequacy at a suppression hearing or in a suppression issue. So where there's something that was supposed to be suppressed, your lawyer did not do a good job. So that he could be ineffective. You can have ineffective assistant counsel there, which can reverse your case. You can say that also contributed to the fact that you pled guilty to something that you would not have pled guilty to had he dealt with the suppression issue correctly. Exactly. So because he failed to do that, it caused me to plead guilty.
Exactly.
But so in that situation, it's compound. So you have to raise both of those issues, and the court has to agree with you on whether or not your lawyer should have suppressed or whether he failed to do that correctly. So if the court does not agree with you on whether your lawyer failed to suppress or didn't do it correctly, then you automatically will lose the second part about your plea was involuntary or unintelligently made or coerced or whatever. They'll say, well, that being the case, your lawyer's representation was good for the suppression issue, so you lose everything after that. But if the court says, yeah, your lawyer failed right there, then that contributed to you. Really, you can resolve the case on the fact that he failed to adequately represent you. But also that if that contributed to the reason of why you pled guilty, then it's like, yeah, I pled guilty because he was ineffective.
Right.
He was not helping. So you got to be mindful